So this is the second part of my episode with Yuliya Guseva, Professor Guseva of Rutgers Law School. Remember, I had her on a few episodes ago. We talked about her research regarding the effectiveness of the SEC. If you haven't listened to it, you might want to go back. Since that episode, the SEC has proposed amendments to Regulation ATS that would arguably capture DeFi, suggesting a broader definition of exchanges that would move from an order-based or order-focused definition to platforms that bring together buyers and sellers using trading interests where they can interact. The definition of a communication protocol system, which was interjected, is particularly expansive. It's any system that brings together buyers and sellers or maintains a marketplace that facilitates the bringing together of buyers and sellers that makes any type of security available for trading. So it's very broad. There's also some footnotes in there that suggest that they are taking individuals who participate in that system collectively. So obviously this could be a tool that could be used to go after DeFi applications. Very concerning. So we would have had a lot to discuss. And when we talked about exchanges like we did on the episode today, because of the recent proposal. So in today's episode, we talk about her potential solutions in addition to the SEC moving from registration violations back to anti-fraud. Again, if you haven't listened to it, I encourage you to listen to that and then flow right into this. We cover exchange regulation, where maybe we have slightly different views, the importance of gatekeepers, disclosures, and the issues that issuers like Blockstack have when they seek to deregister a security. I think this was a very exciting episode overall. I think, again, listen to maybe both of them together, but Professor Guseva's done a lot of great work, and, I hope you enjoy it. So if you enjoyed this episode, please share it with others, and please like or comment to it. Thanks so much. I hope you enjoy the episode. Welcome to The Encrypted Economy, a weekly podcast featuring discussions exploring the business, laws, regulation, security, and technologies relating to digital assets and data. I am Eric Hess, founder of Hess Legal Counsel. I've spent decades representing regulated exchanges, broker-dealers, investment advisors, and all matter of fintech companies for all things touching electronic trading, with a focus on new and developing technologies. What do you think about the notion of that? I've heard this was raised by Dan Berkovitz when he was at the CFTC and now at the SEC, as well as Commissioner Crenshaw, that it's unfair to current regulated market participants that crypto, effectively, that the same rules, that the same structure isn't applied to crypto. What do you think about that argument that it's unfair to existing market participants? Or intermediaries regulated?
Let's look at it at the broader perspective. Shall we protect the incumbents? Are they doing a much better job compared with what the nascent crypto market participants can do in the future? Are there certain cost savings? Is it associated with better efficiencies? So do we have a system, a financial institutional system, which can be improved through crypto, or do we not have? Because if we do, then protecting the incumbents probably should not be our goal, or at least it shouldn't be our only goal. Our goal should be improving, maybe using the incumbents models, but maybe using a completely new approaches to financial markets. So I think that's an important consideration that every policymaker should keep in mind. So where are we going? And I really like the UK approach. In the summer 2021, once again, it was last year. I still can't believe it's 2022. So last year, the UK rolled out its new digital asset strategy, where they said that we should focus not just on the processes, but also on the outcomes, on the results. And this is, I think, what such an important institution as the SEC should also think about. At the same time, they should keep protecting investors, which is their core mission. That's the touchstone of all policies and regulations. But it's at the same time important to foster innovation and promote social welfare, maximizing innovation.
And do you think they're doing that? I mean, the FinTech Hub, obviously, they're focusing on that. Is there an adequate balancing of innovation with the regulation, particularly with regard to registration of the securities as deemed under Howey?
Well, not in the primary market. That's for sure. at least based on my research. When I say for sure, I base that on the empirical data that I have collected and analyzed in my research. We don't see that in the primary market. Instead, there is some kind of stagnation there in terms of providing new reforms, new guidance to the market. And the 2019 framework is getting outdated. We need more from FinHub. We need more leadership, which I'm sure they will provide at a certain point. Perhaps for political reasons, they needed to sort of get their bearings in 2021, but hopefully something is coming up, and that would be an important development. In terms of the secondary market, hesitant to sort of pass judgment on what's happening with the secondary market and gatekeepers. We need better gatekeepers for crypto. We need better crypto exchanges, regulated crypto exchanges, but the current regulations are simply unsuitable. So we need something else. And at the moment, while we have seen some developments in the primary market, we haven't seen much in the secondary market. So the gatekeeping function of crypto exchanges and crypto broker dealers is very important for developing a healthy crypto asset market. And the SEC should pay more attention to that, in my opinion.
Well, Gensler does talk about the need to impose exchange registration requirements on current crypto markets. I can tell you, I wrote a paper on this. I actually think that's a disaster because the first exchange that does it would largely be creating a market for very little volume because there's nothing that would actually qualify. It's like, it's a build it, they will come and just pour money down a hole until they do, because an exchange is a very expensive venture. There may be other more suitable ways to do this and contemplate how do you evolve the entire ecosystem than saying exchange regulation or mandatory broker dealer. Like how do we bring all these different components of the market to a place collectively where it's not like you have to basically lose money or go out of business. I mean, operating a crypto exchange, unless you're including other equity securities into it, and even then, if your bread and butter is crypto, then why do you suddenly become proficient at other equities markets? So it's something that I've every time I hear they have to register as exchanges, I'm just like, oh my God, do you have any idea what that means? Like it doesn't work. It's not like you can't if a crypto exchange dropped out of the sky today, how long would it be in business? I mean, I've advised clients over the years, like, because I was a general counsel for an exchange and advised a number of exchanges. And once there was an exchange that was literally offered as a discount to one of my clients that was becoming an exchange. And I simply said, well, I wouldn't take that exchange if they gave it to you. And they're like, what? I'm like, you couldn't pay me to take that exchange, because the burn rate that they had for all the regulatory infrastructure and lacking the volume was millions. And so I'm like, you couldn't pay me. Ask them how much they'll pay you to take the exchange off their hands. That ended the conversation kind of quickly. But anyway, so I struggle with that whole notion of exchange registration. It's not a construct that makes sense for where we are today. So anyway, this is my interviewing you, not expressing, but I've thought a lot about that particular issue.
Actually, you have great ideas, and they really like your paper. So the SEC stated in the Dow report back in mid-2017 that crypto exchanges, which we commonly refer to as digital asset online trading platforms or crypto asset trading platforms. So the SEC stated that crypto exchanges should register as exchanges or find an exemption and register as alternative trading systems, for example, which would be Reg ATS. So I know you have worked for once. So what are your views on this? I'm a little bit hesitant to express an opinion because I know it hasn't happened yet. So there is no case study I as an academic could analyze. But we have INX, of course, which is on the list of ATS. And it did successfully do a public offering as a foreign issuer in the United States about a year ago. So there is at least one successful or semi-successful example, but most of the others have not been that successful.
Yeah, I mean, it's you look across the marketplace. I think securitized Rialto markets are some of them. I note them in my paper. In some cases, they have a transfer agent associated as well. Those are really like they function better as closed systems, because it's a tokenized security, but it all has to stay within the system. So it doesn't really have that ability to trade outside as well. And so that's the model that I think is challenging, and developing liquidity in that model is very challenging. So, but I think starting with the ATS is sure as heck a lot better than starting with an exchange. I mean, the exchange is just a non-starter. Just a non-starter. Yeah, sorry.
I agree with you on this, except that I always keep in mind one important problem. We need more proper gatekeepers for the crypto asset market. Right now, most markets rely on the transparency of blockchain transactions, the open source nature of the code, so that everyone can read it and some people even can understand it, believe it or not. At the same time, we look at the reputation of the developers, which is also important. But those factors and those variables are really important. Yes, that's true. But at the same time, we still need proper gatekeepers for selling securities or any crypto assets for that matter. NASDAQ published an interesting piece on market manipulation in crypto, and said that market manipulation may happen, and it has happened in certain crypto asset trading platforms. So we do need to ramp up the regulatory oversight of crypto exchanges. At the same time, they cannot comply with the standard exchange regulations.
Right.
And why do I think it's important to keep them as quasi-exchanges? Is that as opposed to ATS, for example, exchanges monitor their own participants. They have that self-regulatory function. ATS do not, alternative trading systems do not do that. Monitor crypto asset participants a little bit more. At the same time, it doesn't mean that we need this common, standard, conventional exchange framework in crypto.
Right. So ATSs are broker dealers, and they do have some monitoring. They don't have the same extensive as exchanges. Exchanges have to have much more developed rule books that cover all aspects of trading on their platform. So, but having said that, it's hard to start to discuss what those proper compliance metrics are when you're faced with the other side just simply saying, well, exchange registration. Like it just, and I think that really goes to the heart of your point about cooperation. Like, you have to build a trust in the market. And if, listen, anybody who gets involved in a dialogue, there'll be people from both sides throwing stones at them. But, because like, what do you mean you're giving up the crypto, the cypherpunks, or, oh, what do you mean you're giving up the incumbents in the market? But the fact of the matter is that the answer lies somewhere in the middle. And, to your point, fraud is important to protect against. And the market, for it to develop in a vibrant way in the United States, probably needs more regulation and more surveillance. There is probably a tendency to overregulate. That's what we're seeing now. And who pays for that regulation and surveillance? Another question. And what do you do when there's utility components that a broker dealer is supposed to be managing? How do you manage that? So I in many ways, I think there's a lot of issues. I wonder whether transfer agents actually could play more of a role in it, because you can't be relying on like the DTCC. That just doesn't make any sense. That's an old model.
It's rolling out the blockchain-based
Oh,
settlement.
listen, I'll tell you, DTCC, the existing model for equities, but they have done a lot of work on blockchain. Anybody who thinks that they're not doing their research, think again. They know this is like right in their wheelhouse, and either they become, develop expertise on it, even to facilitate more efficient equities transactions, pure equities, Yeah, so they could end up ultimately being a player, but not in the existing rubric. And there has to be some flexibility and sort of not mandating you have a single clearing, because how does that work in crypto? Like, we're going to create a single clearing entity for all crypto in the United States. Like, but what about this global nature of it? It's not like we can like freeze the world as much as, despite the fact that we still have fleeting but remaining dollar dominance. We don't have the power to just tell the whole world that they have to come through our platform. So,
well, it may be easier to settle crypto transactions in certain cases. And of course, we have DeFi applications and decentralized exchanges doing that. But back to your point on the exchanges and the liquidity, So we have regulatory issues concerning which exchanges to regulate and how to register them. So we have centralized exchanges. Okay, you have a firm behind an exchange. It's a central entity. It has an order book. Okay, we can register it as a quasi-exchange at least. But what about the centralized exchanges? Who is going to register it there? If there is, let's say, no foundation, or it's all about the code and completely decentralized transactions. So the old model simply won't work in a decentralized scenario with automated market makers, which are most decentralized exchanges. And you also mentioned a very important point about liquidity. It's about liquidity, it's about volume, and it's about simply the number of crypto assets which can be traded freely on an exchange. And there are not that many at the moment. And that gets back to my previous point on Regulation D. If those securities are restricted, how can you sell them through an exchange? Now, we need more offerings, public offerings, or offerings through a separate regime to make crypto exchanges viable as regulatory exchanges, or ATS, in the United States. Otherwise, there won't be any liquidity, the number of securities will be small, and there won't be any volume, of course. And here we need to make a distinction between crypto assets, which may or may not be securities. They're more like commodities, or maybe they're stable coins, maybe they're NFTs or something else, which once again may or may not be a security, and security token offerings, as they refer to in Europe. Security token offerings or digital asset securities are simply tokenized shares of stock and bonds. You can obviously issue them publicly and then list them on an exchange, but it's a completely different type of financial instrument. It's a standard conventional share of stock in the digital wrapping. And it doesn't matter how you sell or offer it. Blockchain may offer some additional functionalities or efficiencies in how you sell and transfer it. So it's the same product with additional efficiencies, and it should be regulated as such, as the same product. But for more novel and innovative and untested instruments, you have to develop a separate regime.
Right. I mean, the U.S. and under, I guess, Commissioner Gensler's engagement, they came up with a whole regime around swap execution facilities. And swap execution facilities probably lay somewhere between ATSs and exchanges. They have a distinction because they do create their own rule sets. It's not under the same type of regime as the SEC, where you have to go through this complicated process of getting your rule sets. Like it's probably one of the most, being an exchange provider, running an exchange platform, anything you want to do, you have to basically broadcast the entire world. That's like a requirement. And you have to do it over a period of months. And then by the time you get it, somebody else is already working on it. Like there's no secrets. But for the CEFs, they do regulate their members. So but it doesn't have the same heavy-handed, expensive approach that the equities exchanges do. So maybe that's an approach to think about it. Who knows?
I agree. There are at least several models that the SEC and the FTC could use to build a more robust infrastructure in crypto. And CEFs are one of those models. And in this sense, it is possible that the SEC and the CFTC should sit down together, create a joint working group, and develop a set of regulations, and then either divide the jurisdiction or come up with a separate division or regulatory entity for crypto and financial innovation per se. An idea that I'm going to develop in the next paper.
You don't stop. Yuliya does not stop. She's publishing more. So excellent. So.
There are a lot of open-ended questions and issues that we as academics have the responsibility to discuss.
Yeah, I actually, my New Year's resolution is to do more in-depth journal articles.
Academics have two issues. We are very loquacious. We talk a lot. And the second problem is that we write a lot and our papers are very long. So if you don't fall into one of those traps and write a great, concise paper, as you have already, so I think it will be exceptionally valuable with all your great experience and background. But in terms of academic research, I think there is a lot the SEC could look into, including law and economics research and research which is informed by game theory and ideas from classical economics, or neoclassical, I should say.
Yeah, I mean, it would be good if they could sort of return to that model of thinking, hey, how do we actually move the markets to an optimal outcome that balances innovation and regulation? Switching gears a little bit, 2021 saw a loosening of accredited investor standards, increasing offering thresholds for regulation, crowdfunding. I also know that now there's some talk, I think, in the roadmap for 2022 about maybe tinkering with those standards, making them maybe more restrictive again after loosening them. Do you believe that Reg CF has been beneficial in achieving the SEC's mandate?
Well, a caveat from the get-go. I have not looked into Reg CF for the purposes of my empirical research on crypto. There have been some offerings, but it was mostly about Reg D in the primary market for crypto assets. The increase that has already happened of the threshold may be helpful. And there will be some gatekeepers because the platforms through which crowdfunding issuers must sell their assets, those platforms must be registered with the SEC, and they do provide a certain gatekeeping function. So that's a positive. And CF, of course, is more flexible than other regulations, maybe not Regulation D, but some others. And also, we've seen an increase in Regulation A as well. Technically, the reforms stretched over the course of 2 years, at least 2020 and 2021, right? And they touch not only Regulation D in terms of expanding the accredited investor definition and adding, for example, the investment threshold. So we used to have, let's say, mainly the asset threshold, but now there is also an investment threshold. So that was one expansion. The other one concerned Regulation A, where the limits in Tier 2 offerings were also increased to 75 mil, which is substantial. And then we had that increase in Regulation CF. So what kind of changes can we expect? First, if let's say investors are buyers, issuers are sellers. If you increase the number of buyers hunting for the same products, it changes the supply and demand curves. The demand is greater. If the demand is greater, issuers will not, sellers will not have to pay a higher cost of capital to the investors to compensate investors/buyers for the risks. So that's a positive for the issuers. For the investors per se, to the extent that we still have a lot of unsophisticated investors in the crypto market, they're going to be hurt. Let's take the investment threshold. Let's say you and I run a fund and we have $5 million under management, so that's our investment, and we mainly invest in real estate. Maybe this real estate is represented by NFTs, maybe not. But then we decide to invest in Solana or Ether or something else. The problem is that our $5 million are not making us a qualified investor. Yes, we're accredited according to Regulation D, but we're not fully qualified. What do we know? We know about real estate. We don't know much about Solana or Ether or the competition between Ethereum and other alternative blockchains, and other platforms. So that's a problem. We need more investor sophistication at the moment. And since there are no substantive reforms, either in Regulation D or Regulation A, except for that raising the threshold, we need a little bit more to protect the smaller investors. Now, with respect to Reg CF and Reg A, once again, raising the thresholds, allowing issuers to sell more is obviously beneficial to the issuers. Whether it's beneficial to investors, well, if more bona fide and valuable issuers come to the market, yes, it's valuable. If we get more fraud, no, it's not valuable. And we need to juxtapose that with this expansion of the definition of accredited investors. Since there is no sophistication component, there is only proxy for sophistication, which is wealth or income or assets, etc. Since we don't have this direct sophistication component, and there are not enough gatekeepers out there on the market, it may result in the problems that the SEC actually has been trying to prevent from its formation.
And is it possible to get a sophisticated investor that's not a proxy? I mean, that sounds kind of, I'm not sure how you would do that.
Now you're asking very difficult questions.
Of course.
And, as an anecdote,
I'm looking for the accredited investor, sophisticated investor quiz to pass or fail.
That's complicated. I think the easiest way to achieve that is through more sophisticated gatekeepers. So let's say if it's broker-dealers, FINRA has to amend its exams for broker-dealers, and that's specifically for certain crypto-related aspects of the market. In some countries abroad, let's say Malta, there are gatekeepers reviewing prospectuses, which issuers distribute to investors. So they sign off on the prospectuses, which is actually beneficial to both the issuers and the investors. Issuers may make mistakes inadvertently, and those mistakes can be costly because they will be sued later if there is a mistake. So having a gatekeeper is helpful both to issuers and to the investors. I can't go into the details here. As an anecdote, there was a Russian mathematician, a very famous one. So he came up with a theory. And when people started asking him how to apply that theory, he said, well, I'm an academic, what do I know? So I'm not like that mathematician. And I believe that better gatekeepers, including not only broker-dealers, but also additional types of gatekeepers. An example is Malta, as I mentioned before. They already exist. And if we cannot improve the sophistication of the investors, we can create more sophisticated and better gatekeepers. We can simplify the code. Some say that pretty soon we will be able to write codes very easily so that everyone would understand them. Well, we're not there yet. So let's start with what we know, and this method is gatekeeping.
Well, I don't know if I'd hold the torch out for simplifying code, because humanity has a way of complicating even when you simplify. So we simplify the code that will basically enable us to create more complex algorithms and actually more functionality, which would be a net good, but it probably wouldn't result. I mean, there would be simple projects, but you'd still have the more complicated projects where you have the same issue. And how do you do the line drawing? And I guess that sort of gets to, like, we touched on it a little bit, this notion of disclosure and what's the appropriate disclosure, because you have the regulated, mandated disclosures that are extremely cumbersome. For like a Block One. Block One was struggling with all the disclosures that they were mandated to do by statute, but yet were incompatible with the way they actually operated their company. How do we resolve this incompatibility?
There have been only 5 offerings which can be qualified as public or mini public. There were 4 Regulation A offerings and 1 offering on the Form F1, which was a public offering by INX. So these 5 companies we can use as some kind of case studies with respect to A, how difficult was it for the issuers to get their statements qualified or the registration statement declared defective? Whether the issuers struggled with corporate disclosures, periodic disclosures post-offering. And let's answer the first question first. Let's take Blockstack. It was the first issuer whose Regulation A offering was qualified by the SEC. And it took the company, I think, more than 9 months, if my memory serves, to get it qualified. That's ages. That's an enormous amount of time in crypto. So Blockstack got lucky. Its project did not get outdated by then. And it also got lucky that it had backers from the venture capital community. It also did various capital raising rounds before the Regulation A offering. So it had the time and opportunity to wait for the SEC to get the offering qualified. And that was 2 years ago. at the time, the SEC faced a steep learning curve. So there was a lot of back and forth between the corporation finance division and the issuers. At the same time, around the same period, the SEC did not approve any forms S1 filed with it. That would be for initial public offerings. The SEC just didn't know how to do that. So they approved Blockstack, and in the prospectus, in the offering circular, and later on in the periodic reports that Blockstack had to file, because they had an offering under tier 1. And if you do this offering, you have to provide some periodic disclosures. So they did tier 1, and then they started providing periodic disclosures. And in both the offering circular and the periodic disclosures, they repeated several times that their board would continuously evaluate whether the Howey test applied to their assets. And as we discussed in the beginning of this meeting, Eric, the Howey test is very functional, broad, and very capacious. You can fit almost any instrument, financial instrument, under within the scope of this test. So Blockstack probably struggled with that. And if you think about it, if, let's say, they got it wrong and they actually rolled out a second iteration of their program, their platform, I think less than a month ago. So their tokens are no longer considered securities, at least considered by Blockstack. And we'll see how the SEC will react to that. But my hunch is that they cleared that with the SEC somehow. So they rolled out a more decentralized version, and now they say this is not a security. Consequently, they would have an opportunity to terminate their reporting obligations under Regulation A. So, but what if they made a mistake? The SEC could come after them, and private plaintiffs could sue them as well. So they opened the door for an additional liability risk. And who was responsible for making the determination that the stacks were no longer securities? It was the board, per the circular that I just mentioned and the periodic reports that Blockstack filed. That's an additional obligation for the board members to look into this whole panoply of potential permutations of the Howey test. And there is a lot of case law. Remember, the case dates back to 1946. We are a very litigious nation. We've had a lot of cases about the Howey test. Plus, we have the framework which provides from the SEC, which provides multiple examples of what a crypto asset may look like to be qualified as a security. So the board had that enormous responsibility. The lawyers of Blockstack also had that responsibility. The accountants had to think about how to qualify that asset on the balance sheet as well. So there is a plethora of questions that we need to deal with. And hopefully, Blockstack successfully resolved all those issues, and now stacks are more decentralized assets, and hence possibly not securities. But I guess we'll see. The future will tell.
Yeah, it definitely wasn't a capital efficient exercise for Blockstack. Basically they went through all the work to qualify and then did it for a certain period of time and then had to sort of unwind it. So it couldn't have been very cost effective. But the liability would also cut both ways, right? Because once in Blockstack's case, they actually needed to conduct that continuing evaluation, because if they were moving toward the decentralization, they may not be able to make all the required disclosures, and then could be subjecting themselves to liability on the other side. So a lot of projects probably wouldn't want to be having to comply with securities regulation perpetually, particularly if they're also moving toward decentralization. At a certain point, they just become a bucket they just become a target for liability because they weren't able to comply because it wasn't within their control.
Absolutely. If a project is sufficiently decentralized, so there is no central party controlling the platform and hence the asset value, or the transactional flow, etc., etc. So if there is no centralized party, the project is decentralized. Also, the market determines the value of the assets. It depends on the network effect, the volume of transactions, the community of developers working on improving the project, etc. All those factors are unrelated to the issuer. The issuer doesn't control those factors. Should we make the issuer responsible for providing the market with reports about the platform, which the issuer doesn't control? That's the question that the SEC needs to answer. At the moment, it's not just the SEC. So I'm not assigning some kind of guilt to the SEC here, because every regulator struggles with the same questions. Every regulator around the globe. Decentralization is something that our regulatory systems have not anticipated. We focus on the regulation of intermediaries in many contexts. Let's take AML, anti-money laundering frameworks. There we focus on the intermediaries, how to address decentralized exchanges and peer-to-peer transactions. We don't know how to do that. Once again, the FATF framework and the SEC and FinCEN are putting the onus of looking at the AML policies and complying with the AML requirements on the intermediaries. How long are we going to do that? That's a big question, and which in part depends on how decentralized our world will become in the coming years and how soon it will move towards decentralization.
In your paper, you also referenced this notion of the impact of slippage in the context of a public filer. Do you want to expand? And I think you touched on it a little bit with Blockstack, in that you talked about how things didn't change so much that they were able to actually make their filings without suffering a lot of slippage. But maybe you could develop on that a little bit.
So the concept of slippage is related to the work of many other scholars. And one seminal work was published by Professor Henry Hu of Texas Law School. He focused on the securities which were circulated during and before the financial crisis. And many of those securities were heavily data related and data-based. And if someone looked at the data, that someone would have realized that we were on the precipice of a financial crisis. Issuers per se sometimes didn't even have the ability to analyze, let's say, all those mortgages because they were too complex. So sometimes we need to look at the underlying data. And this is the most reliable source of information. At the moment, this is not how our disclosure structure and reporting structure is created and designed. We have an issuer disclosure paradigm specifically. We require that issuers disclose information to investors. So an issuer looks at the project or a firm, digests this information for the investors, drafts multiple and very lengthy and costly disclosure documents, starting with registration statements and prospectuses in public offerings, and ending up with forms 10K, 10Q in periodic disclosures and other forms. An issuer does that. But this issuer may not have the most complete understanding of its project if the project is very complex. And sometimes it's just easier to look at the data. And community members in the crypto community can analyze the code a little bit better than the issuer can. We have third-party auditors who are not regulated at the moment. Many of them are not regulated, at least. They can also look at the code. So we have this global community which constantly reviews open source codes disclosed through repositories such as GitHub. In this sense, when an issuer looks at the code and tries to draft those disclosures in order to proceed with an offering of securities, and it is possible that there will be some slippage between the meaning of the code and the actual wording of the disclosures. We also have the so-called plain English disclosure standard, which was developed by the SEC. It's pretty dated in certain respects. It is useful, that's true. It helped the SEC and the market simplify formally convoluted prospectuses and the language of prospectuses, and that benefited our investors. At the same time, it doesn't fully capture the technological developments we are faced with. So you take this plain English and the limited tools of the English language, and you try to superimpose it on the code and describe it. Now, why is that problematic? that there is a potential slippage between the two, the actual code, which is the main asset of the firms, crypto firms, and the disclosures that they may file. Well, what if they don't get it wrong or completely wrong? What if there is a misstatement which the court might find material? In this case, our issuer would immediately be subject to liability under the Securities Act, specifically sections 11 and 12A2. One refers to misstatements, material misstatements, and omissions in registration statements. The other one applies to prospectuses and is also relevant not only in the context of public offerings, but also Regulation A offerings. So we have these two provisions which are very pro-plaintiff. Our issuer, through the slippage, through the complexity of the code and inadequacies of our plain English disclosure, our issuer may expose itself to additional liability.
Particularly if there's also even changes still going on to the code while it's
Exactly.
right.
Exactly.
In your paper, you had also talked about why certain disclosures may be more valuable than others. I think in particular, you focused on human capital disclosures might be more relevant than other mandated disclosures. Do you want to expand a little bit on that?
Human capital disclosures are an important piece in all innovative projects, especially if those projects do not have many assets. Brick and mortar companies have a lot of assets. Their creditors and shareholders, as residual owners of firms, can get a claim to. With crypto projects, many of them, especially the valuation of those crypto projects before an investor commits to invest a certain amount of money, those projects are based on how intelligent, how talented the entrepreneurs are. The developers are the key asset. The team behind a project is the key asset of many crypto asset firms. The same actually applies to many big tech firms. Amazon, Google, Apple would not be Amazon, Google, and Apple without their personnel, without their staff, and without their human capital in general. And this is particularly true for smaller startups. And to an extent, it sort of harkens back to what the disclosure rules began with. We, in the past, the United States disclosure system focused on the promoters of certain projects, focused on whether those promoters had the right incentives, not just disclosures relating to the business of the company, but also the disclosures related to who the promoters are and whether their incentives are aligned with the future of the project. And the new reforms by the SEC hopefully will move us in the right direction. There will be more human capital disclosure, more holistic human capital disclosure. At the same time, research shows, not my research, but my colleagues' research, and I think Professor Georgiev from Emory is about to publish a paper on this. So a lot of companies do not provide enough information of human capital, and we need to nudge, and I think we need to nudge human capital disclosures in the crypto offerings, because this is where it's particularly important.
Great. So I'm gonna close out the podcast talking a little bit about our home state, the Garden State, New Jersey. I'm going to juxtaposition two different bills that have been put to the assembly, and they're interesting because on the one side there's a Democrat version of a bill, and on the other side there's a Republican version of a bill. And again, I'll throw in my lament about, I would give up favorable provisions, favorable crypto provisions in a bill for the benefit of having something that could just be supported bipartisan. Because as an aside, the notion that this technology is becoming, in some cases, appears partisan isn't something that inures to the benefit of anybody. But with that little piece aside, there's the Digital Asset and Blockchain Technology Act in the Assembly, where one of the thrusts of it was the need to provide licensing, much like the BIT license in New York, which has been criticized due to its challenges. And then on the other hand, you have a more recent bill that was proposed called the Virtual Currency and Blockchain Regulation Act, again, which is this one is a Republican-sponsored bill. It has a lot of very intriguing positions. with regards to the treatment of digital assets as property, intangible personal property, classification as property, which is something that I've been struggling with a bit in my practice, recognition of decentralized autonomous organizations, a blockchain filing system, an exemption from money transmission laws, authorization to issue stock as certificate token, incentives, the ability to use it to pay state taxes. I look at it and I say, I don't know, honestly, whether this is sort of like a pitching to particular voters so that voters will vote for a more pro-crypto candidate than one that is, talking about enforcement and protection, or whether, or what aspects of this actually have the likelihood of getting some sort of consensus, in the Assembly and the Senate. Do you have any? I guess you're familiar with the statutes to some extent. Do you have any thoughts on them?
First of all, I'm neither Republican nor Democrat, and I do not like politics. I believe
Can't imagine
policy.
why in the U.S., but anyway.
I believe in good policies. I guess as someone who was born in the USSR, I really hate politics. Consequently, I always believe that truth is somewhere in the middle. And we always need to apply a balancing test. We need to look at the benefits of regulation versus the cost and the downsides of regulation. And now we have a good historical record we can rely on. We can look at New York with its bit license and enforcement actions, and compare that state with, let's say, Wyoming, which has been much more pro-crypto. It has Kraken, let's say, has a license there. Wyoming introduced a DAO, which may be qualified as an LLC in Wyoming now. To the extent that some people may say that that law is completely erroneous, that corporation law is completely wrong for DAOs, that's a completely different question. The main point is that Wyoming has been trying to attract crypto companies and improve its legislation. We also have states like Arizona with its sandbox. Now we get to New Jersey with its two completely different bills. My hope is that the two bills will be reconciled at a certain point, because the bit license has been a little bit too restrictive, and it drove some valuable companies out of New York. It is possible to comply with it, but to the extent that it's expensive, only larger companies can comply with that. For startups, either a different type of license can be proposed, or they can be a sandbox, following the Arizona approach, let's say, in New Jersey. And I hope that New Jersey will move down in this direction. And I need to mention that the Bureau of Securities of New Jersey has been doing a pretty good job monitoring crypto markets in terms of fraud. So we just need to move a little bit beyond fraud towards a more robust infrastructure for crypto assets.
Right. And also notably, the New Jersey Securities Division, I think they were one of the first states to go after BlockFi for their credit offering, which was, again, I don't know whether that's telling for a bias. Hopefully not. But, certainly it's something that we can all hope that more bipartisan approach on this would be so welcome. So welcome.
Exactly.
I mean, anyway. But
we need to leave partisanship in 2020 and 2021.
100%.
It's the new year,
100%.
and hopefully the new era for crypto.
Seriously.
And regulation.
Julia, it was great to have you on the podcast. We talked about so much, and you've done really good work with these papers and digging into statistics and presenting it. I mean, I think it's invaluable. Like, people can talk anecdotally about, hey, I experienced this or I experienced that. But when somebody takes the statistics and compares it side by side, that lends an element of credence to observation that we might not already have. So thank you.
Thank you so much for inviting me, Eric.